But before that, or maybe you can introduce yourself, then I'll talk about the conference for 1 minute. And or,
Okay.
or do you want to,
Okay.
or maybe look, we are 2 minutes before time. So why not talk about the conference first? Then
Okay.
might that be better, because otherwise there will be your friends, your or your, what I would say, your fans who will be waiting there. So let them let them hear about you. So let me just go through what the conference is.
Okay.
So basically, World Mediators Conference. Idea is Mediation Vision 2026, evolution of mediators and mediation. So 18th May to 30th June. 18th May was the opening session by Ken Cloak. I don't know, Nicola, whether you saw that or not. Did you see
I
that?
did. I did. I saw it on YouTube.
He's always, I mean, it's always a pleasure listening to Ken. So that was nice.
Yeah.
So
Yeah.
basically, we have, yeah,
I've actually read some work from him, and it kind of kept me going in in
mhm,
in 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 times of pushing through and wondering, should I do this or just drop it. But
not bad.
it's been I don't know. Most, if you read the work of established mediators, you just, they keep the light on and pull all of us who are going into the field further, and making us all want to be better.
No, yeah, absolutely. But what I do is give me, I mean, we have, okay, we are actually on time. So like quickly, there's the schedule up there, which is obviously on my post. So all this has happened. Basically, very simple. The session, the date, the time, the session number, the YouTube link. Simple. So of course, we have lots of sessions which have happened, lots of sessions to come. So basically, we are right now, we are just here right now. Imagine.
Yeah.
We're at 25. This week itself, by the end of this week, we would have done 37. Then of course we have lots and lots of them coming up. And I've still told people, I mean, if you come in, you have something to discuss, let me know. We'll put in something, we'll fix a time. I don't want anyone who has a thought to be left behind. This mediation in criminal cases, there is Pascal. He's also in, where is he? Isn't he no, he's in Netherlands. So he just sent the book that he's written, and with a nice,
Excellent.
very nice message on it. I should have kept the book here. Very nice message he sent on that. It's always nice when someone appreciates what work you're doing. So it just feels nice. Okay, so this is just a quick look at what it is. I mean, I don't know whether you've also seen the schedule properly, but you have to keep your time for one of these, both the slots if you have to. 30th,
Okay.
learnings and key takeaways, you have to be part of that. So on the sheet, you go to social media posts, all the LinkedIn posts. Please share these posts. We have to reach people. Then here we have the panelists. So that's about it. Some broad points I'd put out. I mean, we can always add more things to it. So that's how simple it is. Perfect. Done. Great. My job done, Nicola. Now it's all yours. So basically, we are talking about investor state mediation, and it's Nicola's show now. Nicola, please introduce yourself. Take it wherever, and I'll come in whenever you ask me to come in. Thank you for coming in.
It's my pleasure. My name is Nikola Tomic. I'm a mediator from Serbia. Uh, I have been, I don't know, reading and doing some sort of investment law since my master's degree, and it's a field that it's, I don't know, it's out there. It's new, and it's not new. It's something that requires a specific set of skills, and it's bigger, it's broader, it's more and more involving. As much as you think that you know about it, there's always something more that you can learn. And as for the investor state mediation, that's a new field, and I think that's been in development for about 10 years now, since there's been usually arbitration or domestic courts as a dispute settlement mechanism between investors, states and states, investors and states entities. And for about 10 years, there's been a wide range of international organizations and mediators who have been involved into developing this field. And I think it all started with the British Institute of International and Comparative Law empirical study in 2012, which they published 2 more. So the survey paints the landscape for investor-state dispute settlement mechanisms, and from their point of view, the costs and the timetables and I maybe not timetables, but duration of investor-state disputes have been overly complicated for all parties involved, and investor-state disputes as such are big. They usually involve more entities. They are usually multi-party, even though it's 2 parties, but there's always different entities from one state who are involved in the process throughout the investment, and especially when the dispute arises. So they have been diligently working together with UNCITRAL, CEDAR, IBA, ICSID, and lots of people throughout the world to develop a more favorable dispute resolution mechanism, which is investor-state mediation. And I just wanted to paint the landscape a bit for everyone to understand. If you look at arbitration, which is the most commonly used dispute resolution mechanism for investor-state disputes, the amount of disputes have risen throughout the years, and it's been going just a bit higher than the last year, even though those cases are big and complicated. They are, I don't know, they started to become more complex. They started to become more expensive, and as for the costs itself, for the states, it's usually around $4.7 million. For investors, it's $7.2 million, according to the last survey of the British Institute. And there's been a duration increase throughout the past period, and now the arbitration process lasts for about 4 and something years. And when you look at that dispute, that means that in terms of jobs and local communities and state functioning the way it should be, and investor making its return and doing his business as he intended to is on hold. Nothing happens, or very little things happen, and the problem escalates further and further. And the mediation is a way to go, is something that should be further used as something to resolve all of these problems. And for now, it's starting, it's developing. I certainly have trust in everybody's effort to put it out there and make it more convenient for everybody. The 10-year result of the everybody's hard work is the new ICSID rules for the investor-state dispute resolution, for mediation rules, and Energy Charter Treaty also made some changes and facilitates energy disputes. IBA also declared some rules. UNCITRAL has been diligent in their work to provide a favorable mechanism for everybody. And the Singapore Convention is something that will surely be beneficial for everybody who are involved in these types of disputes. And for now, and according to the expected results of investor-state mediation, there should be much less costs, as mediation provides, much shorter duration for the dispute, and the most beneficial part should be preserving the relationship between the investor, state, and everybody else, because that is the goal of mediation, to provide everybody a favorable solution to the problem. And it can resolve non-monetary questions that arise, because arbitration or judicial systems are traditionally focused on monetary damages and just to, I don't know, resolve who is guilty and who is not, even though it's a civil procedure matter, but they usually decide who is guilty and what is the amount that should be paid. And that is one of the issues that was mentioned in surveys that were broadcasted and published online, that investors claimed for I don't know, average $1.5 billion in claims, and the amount that was granted to them was 438, I believe. The point is that the bigger the claim, the larger the discount, and considering the duration, the costs, the stress that can provide for everybody involved, you did what? What was the end result that you got? You got an end to a relationship which you wanted to commit for 10, 15, 5 years, even 20, whatever you wanted, planned, and now it's come to an end. There's lots of people without jobs. You lost part of your business. The state lost a partner. Usually it means a significant partner who did something for everybody in the country. And the mediation part here allows everybody to resolve all of these issues, continue the relationship, preserve the investment, let you do your work in terms of what you need. And it's been a long road maybe for someone, but I think it's a great international effort and should be valued. And this is a place where all of us should say thank you to all the people involved, and congratulations on your hard and diligent work.
Perfect. But only thing, Nicola, the thing is that, of course, you have to educate us totally on that, but you haven't spoken enough about yourself. You just said, I'm a mediator in Serbia. It doesn't work that way. There is lots more about Nicola that we need to know.
Okay, I'm a master at law. I used to work as legal counsel at the defense company here in Serbia. Now I'm a full-time mediator. I have lots of experience in international negotiations and dispute resolution. I don't like the judicial system. I prefer mediation. Mediation is for me a way of life. So I fully dedicated myself to doing this work, and I continue to educate myself and provide everybody. Whenever I find something that is of interest and that is new, I go to everybody who is a colleague and share. I believe that's the way all of us should go. Just share and let everybody advance together. I don't know.
Also, you have to tell us about your experience as a father, all the things that you have to take care of. That's also an important part of you.
Oh,
you can't leave that behind.
Well, I'm a father of a 2-year-old girl, and she's been the joy of my life, and I take care of everything I need just to make her happy, see her smile. And that's the most important part of my day, just to see her smile and I don't know, play around and goof around with her. I will even got I don't know, scolding from her that I'm goofing around too much. So, but I believe it's therapeutic for everybody to enjoy the children's energy and just go with it. It will take you places you never thought of going, and it will give you energy you never thought you could get. So that's the entire point. You have to find some place for you to get that kind of energy. We're all serious, we all do the work, and we all smile and joke around, but the particular part of us which needs the most energy and gets the most energy is that one. That's my experience as a father, and even though I spend a lot of time with my friends and family, and there's nothing that can bring that much joy and energy into my life than her. So
Yeah, Nicola, you use the word energy so much. We had a special session on life, energy, and mediation. So that was, look, people don't understand this energy. It's a word used, and the experience of it is what people need to know about. And I of course,
yeah,
of course, discuss that a lot about these aspects of mediation, which sometimes get left out because there is that whole theoretical and certain box which goes around. So perfect. But I'll tell you what, Nicola, the now thing is that the A word is something I don't use on my show. So I call it the A word. Today I will use it. I'll say arbitration because I don't like to talk about it also, because obviously, look, first of all, people are so confused. If you say mediation, they'll say arbitration. So I don't like to use that word at all. We have nothing to do with it. But here
okay,
we'll have to discuss this only for the reason. Of course, you mentioned some reasons why it has not taken off. I mean, in the sense why they're disillusioned with arbitration. So based on that, we'll have to, of course, one, see that mediation doesn't go that way, because I do hear criticism in terms of the pool of arbitrators that are there for investor state disputes. It's not a diverse pool. So of course, I hear now of a lot of nations are renegotiating their bilateral investment treaties. They do not want arbitration in it. So it's an opportunity to bring in mediation, yes, but we should not have the same issues coming up in mediation. So diverse pool is something we have to discuss. Is there not? Is there a diverse pool in mediation available for investor state?
well, from what I know, the pool is still forming and it's diverse. I believe it's diverse. From my training, we had people from Singapore to British Columbia, and there's a lot of great potential there. I met a lot of great people with great experiences from life, mediation, business, whatever you want to call it. But I've learned a lot. I hope that I joined that pool with them. They had some insight from me, and all of those people are, I don't know, trying to carry the torch, trying to proceed further, find some place for mediation that is higher and provide everybody with a higher purpose. And when we discuss how mediations work in their jurisdictions, there's a lot of diversity there, and there's a lot of different issues and questions and experiences. Even in my home country, we all learn something. And considering that the investments are everywhere, they are happening in almost every area of business, there should be a lot of people there. It needs, I believe, a lot more people to be involved in this area, because everybody has different expertise, whether it's oil, mining, some other types of I don't know, road construction, factories. Every possible industry that is out there has a need to educate mediators in this field, just for I don't know, discussion purposes, if nothing else, because
But
they can educate you further.
particular, have you actually, I mean, seen certain renegotiations which have happened on bilateral investment treaties? Have you looked at any of them where arbitration was an issue for those countries? So have you had a look at any of that?
No.
Okay, because specifically there are some countries who actually did not, I mean, they had issues with the arbitration. So they actually have removed that from some treaties. Of course, they have to renegotiate them, so that takes its time. So that's why I'm talking about it, is only because that's a good opportunity to come in. Because if they're disillusioned with arbitration, it's a good time to come in.
Yes, but there's a broad selection of arbitration clauses from BITs or regional investment agreements, and which all have several dispute resolution mechanisms. You can use arbitration here or there. You can use domestic courts here or there. You can use there isn't many mediation provided in BITs, but as for the renegotiation of BITs, what's the issue? The issue that presents itself is that the world is much faster. There are still BITs, even here in my home country, that were signed in 36, I believe, who are still valid.
Yeah.
So you cannot function on principles which were for that particular time. Everything is digital now. Everything moves much faster now. Funds, people, goods. When you look at European Union, you can live in Poland and move to Madrid to work there. And after COVID, there's a lot of people which I know that work from home, and they're everywhere around the world. Nobody cares where you're sitting. And if you function on principles that do not follow the life, do not follow life, that's the only thing that needs to be renegotiated. And as for mediation, you can always invoke it. It's a matter of your choice. So if you choose to preserve the relationship, if you choose to resolve the matter quickly and resolve all of the matters, there's no stopping you. Why would you not, even though BITs or particular investment contracts don't provide for such a clause? You can always make the offer.
Yeah, but I still feel that we need to, of course, look at it from this point of view, that some countries, maybe mediation hasn't developed enough. So their faith in mediation, or them looking at mediation as an option itself, that part of it also we'll have to consider, because you're trying to tell them that if you haven't really developed it in the domestic market as such, but you're looking at it from these treaties. What do you think on that? Is there something that you've thought about on that?
Yeah, well, I believe the core problem is with the educational system. There isn't much educational institutions who provide for negotiation and mediation training. When I went to law school, we we only learned about classic judicial systems and classic dispute resolution, which is in courts. And you have an option to learn about arbitration, but if you know about it and have an interest in it, you will take it, but it's not mandatory. It should be mandatory. All of the legal professionals should learn that as for dispute resolution mechanism, there's the court, there's arbitration, there's mediation, there's combinations of those dispute resolution mechanisms. There's been an increase in developing further ADR mechanisms, such as early neutral evaluation, fact-finding, conciliation. You have a ton of options there, and most of education institutions, and I mean law schools there, do not teach about those.
Yeah.
So when you have to advise a client as a lawyer, you stick to your guns and just advise them to go to court because you know about the courts.
Yeah.
This is something that all mediators need to work on, and especially with the recent developments in mediation. I mean, it's not just about investor state, it's about mandatory mediation, it's about mandatory first meeting with the mediator, it's about whatever you want to call it, but mediation is getting traction, I don't know, for several years now, that has been greater and greater with each passing year. It shows results, but it's a different topic, and maybe we should save it for a different day. But for now it's there's little faith, because so not so much people have gone through it, and when you don't know anything about your role in a mediation process or your role as a negotiator, you won't do it.
But I mean, Nicola, do you think there's a lobby which would not want mediation to be part of these treaties? The same way when we say about in the domestic market, there are lawyers have a resistance to mediation. So do you think there is a lobby there?
Possibly, yes, but I haven't heard about it.
Okay.
There's always people for and against, and considering I've been focused on and learning so much about investor state mediation, and I usually just follow, for now, I just follow the people who are for. I haven't read any articles or blogs or whatever from people who are against it, because I think that for now we should all be banging our heads together, carrying the torch further, and just shouting yes.
Yeah, no, but the thing is that's let's look at it. It's a big market. Arbitration and investor state is a big market. So for obviously, like I said, obviously where countries are wanting to get out of them, renegotiate them, remove arbitration from that, of course, they won't be able to do much about it. But otherwise, how they're looking at it, of course, we'll have a look at it, because I'm sure there are statistics available. How much has been spent on that arbitration in the world on the investor state? I think should be an interesting statistic to take out. But tell me also, do you think that the way because look, my mediation is like the elephant and the blind man situation. Everyone has their way of what is mediation. So now all these models that went around the world that, oh, mediation is only facilitative and it can't be evaluative, all those things that happen. Do you think that also will in some way make a difference in getting countries to make it a part of their treaties? Is there any, I mean, I'm just thinking, it's a thought in my mind that how do they look at it?
I think it's an adaptation issue, because there is no reason for countries to deny mediation for everybody, especially now. ICSID sent out the proposed rules for all the ICSID convention member states. The rules are in force. Countries voted for.
No.
So even if there is people who are against it, the majority ruled. So for now, it's an adaptation issue. There's been big development in mediation field as such, with the Singapore Convention, with the ISDS rules, with Energy Charter developing their own mechanism, even though it relates to investor state, but there's been an adaptation to provide a better dispute resolution mechanism. The A word, let's use your term, was the primary in international disputes for several years, but it's become too expensive. Like I said, $7.2 million for the investor and $4.7 million for the state. That's $12 million just for costs. And when the dispute claim is for, let's say, $100 million, that's 12%.
Yeah.
So even when you, if your claim is awarded, and seeing the trends where there's a big discount for the claim, you lose much more than you gain. Let's say your claim is for $100 million. You get $70 million for the claim awarded to you, and you have to pay 7 of those, and that's 10% for the costs. What did you get? You effectively lost. You lost the business. You lost the case. Whatever money you got out of it is too little. I believe it's little. It's better for you to sit down, negotiate, renegotiate everything through mediation if necessary, than to go to other mechanisms, and even if it's a local court, and end the relationship. That's the point. That's the whole point. And use whatever you have time and money left just to, I don't know, mitigate the damages. So in terms of gains, what did you get? In the end, what did you get?
Yep.
Ask yourself that.
I think, look, in terms of getting the figures on how much is being spent is not difficult, because that report that said what is that mean amount spent by investor and the state, I think it says about, I think in 2020 maybe there were 273 of them. So we just have to we have to do some calculation that we can get the figure. That's a huge figure, that amount which is being spent on that. So definitely, but this thought about my model aspect of it is not something that you want to maybe just consider for a discussion, that some countries might not be looking at a facilitative model, and some countries, because
You don't have to use the facilitator model. You can use whatever mediation style you need. There are mediators who are legal professionals. There are mediators who are investment experts, and you can use their knowledge. They can not just facilitate the conversation, but they can participate using the evaluative or narrative style. They can use whatever you need, and proper mediators are flexible. They adapt to the situation. They help the parties to reach the most favorable settlement.
I don't know, but I am picking in this up is because of the fact that whenever, again, to get mediation into the picture, there will be there will be critics of it saying that, well, this is this kind of a model will not work for us. Whatever we require is different. I don't know what kind of arguments will come up. So we have to first of all educate people on mediation itself.
Yeah,
I think that itself is a whole task.
Agreed. That's why there's a unspoken rule for every mediator to share the knowledge. Go out there, put yourself out there, and talk about mediation. Educate as much people as you can about it.
Tell me about it. I didn't know about this. How do you do that? Please tell me. How do you do that? I have never done that.
Yeah, and when I started my journey into mediation, it was all straight and narrow, and I know I felt like that was it. But the more I talked with mediators, who are experienced, the more differences I saw. Everybody has their own style, everybody has their own approach, everybody has their own needs, not just as a mediator, but when we were discussing cases with confidentiality invoked. But discussing things shows us that you have to be flexible in order to be a good mediator and just adapt. You're the last one that gives up. You have to. That's the role. That's the job. That's the way of life we all wanted to do. We
But
chose, and
but Nicolette, is there any particular example we have of mediation being used and how, what happened? I mean, do we have some example as such?
for the investor state.
Yeah.
Sorry. Well, these types of mediations are secretive, so I haven't seen any case law that can provide that can paint a picture, but I can provide everybody with an example we did in training. So when there's an investor state dispute, the investor is a mining company, and there is a lot of local community protests about the company. There's an indigenous tribe protests against the investor. The protesters are trying to break into the factory, and I'm in the investor side, and the state is wary on how to approach this, because there is significant stronghold for the main opposition party in the area where the investor is located. So in terms of looking at the process, there's a lot of different stakeholders. Everybody has some issue with the investor. The investor has several issues with the country for breaching full protection and security, for other reasons, breach of contract, and the state needs their own problems solved. They need to win this in order to gain their own stronghold for the upcoming election. So the process itself is something that must be considered carefully, mapping out the issues as usual, but you have to map out the stakeholders also, because you need to know who is involved. You need to at least try to resolve as much issues as you can. And when you're doing this type of disputes, you need to map out all the state entities involved also. You need to have all the people who are involved in the investment at the table. So it's a big conversation. It's something that requires much skill and requires much energy. But for now, the proposition and the rule now it's a rule now, sorry, that these types of mediations be done as co-mediations, because you probably would need somebody with experience, somebody with a cultural background. That's also one of the issues that need to be mapped out. There's an investor from India investing in Serbia. Our cultures are maybe similar at some point, but at some point we're different. So in order to avoid misunderstandings and avoid communication issues for you as a mediator, you need to have competency in cross-cultural mediation. You need to have a background, at least in these types of conversations. Let's call them conversations. And after you mapped out everybody, you have to map out the process with everybody included. Which issue will be discussed when, with whom? It's a big question, and you have to be very, very, very careful. Like I don't know
I'll tell you, whenever this aspect about mining projects comes up, obviously what's happened in Peru and the good work that has happened in terms of using mediation in those cases, I think that's been quite successful there. It seems to have worked there. So I think the advantage is, like you said, look, we have a community being affected. Now,
Yeah,
obviously, mediation seems to be the only way to get, first of all, their voices heard and
yeah,
their concerns taken care of. And it's much more than, it's not, you can't be a decision. You have to take into account a lot of factors, local factors and everything. So that has to be pushed. This aspect has to be pushed. But
yeah.
tell me, I think, of course, conciliation the word has been used in treaties. So
Yes.
how are people looking at conciliation? Are they looking at it differently from mediation? Because for me, I'm telling you, I have this whole discussion in India because our law is called conciliation, because the UNCITRAL was using the word conciliation when we took the law. That law came up in 1996, and I have to keep explaining to people that that is mediation, because UNCITRAL has changed its terminology today, and they have said so in the model law that they've taken out on mediation. They've clarified this aspect, but still people don't want to understand that. But in terms of the investor state, that conciliation, how have you looked at that?
Well, I believe that conciliation should be used when there is a technical issue. And when you can use mediation, but you need the competent mediator in the issue at hand.
But
And that,
you're differentiating mediation from conciliation.
yeah,
In what
yeah,
way? In what way?
it's you can use technical experts in mediation. That's not a problem. But when the technical issue is substantial, and when it's a main issue, you need somebody who can assist you in discussing matters at hand. And that's why you're better versed in conciliation, and it's conciliation is maybe a better choice for you at that point. But when you use technical experts in mediation, those are people that are just, they are expert witnesses, they are fact finding, they need to provide, you can agree to give your documentation and everything for a technical expert to say his own opinion, and you can both agree to it or not. But in mediation, you can talk much more freely. You can have another discussion, maybe deepen the relationship. Conciliation, in my opinion, is something that is much quicker. It's substantially focused on technical issues. I don't know. It's
Look, no, I think this is the same. Look, the discussion on conciliation and mediation will definitely always keep taking place. That is there a difference? Because in jurisdictions where mediation is purely facilitative, they will say conciliation is not mediation. While that's exactly what I'm telling you. That's why I like this discussion to happen, and this we need it everywhere. We need it in the domestic situation. We need it in investor state. That is conciliation as provided in certain treaties. Is it mediation or not? That part of it, because look, I'm clear. I just go to the Singapore Convention and I see the definition there. That's my starting point. Because I mean, if specifically there's a definition for conciliation, we'll consider that definition. But if it's not there, that definition, if you had a look at it, is nice and broad. It says, however the process is conducted, whatever the name, whatever expression used, as long as the mediator doesn't have the authority to impose a decision. So in
yes.
that conciliation, it's a non-binding thing. It's not something that the parties have to accept. So in that kind of a situation, do you want to say that it is not mediation?
Well, when you have somebody who is discussing the matter with you and giving his own opinion on the matter, that maybe is something that is more suited for conciliation. And when you talk with a mediator, especially in facilitation jurisdictions, he should, and by practice, he should restrain himself from choosing a solution for the parties. Parties need to agree to a solution themselves.
No, because Nicola, the thing is that suggesting a solution, which is not binding on you, is that an issue? Because I'll tell you what is the problem that is happening, which is, again, I'm saying from domestic to investor state, the same issue will keep coming up. The user doesn't understand all these things, and we keep confusing the user by saying conciliation, mediation, the facilitative, evaluative. Finally, it comes down to that. Basically, what people don't, some jurisdictions where it is purely facilitative don't like the usage of the word conciliation because they say it's evaluative. But how did that word come up? On what basis? Was it supposed to be something which was different from what we understand from mediation? I don't think so, because I'm very clear that today, if you going to quote the Singapore Convention and say that investor state will be good for parties because Singapore Convention is coming in, we'll have to look at the definition in the Singapore Convention. And I don't see suggesting by the mediator making it go out of mediation, because, like I said, should not have the authority to impose a decision is all that is required. We can put it up. I'll put up the definition. I put it on my website, my mediatorvikram.com. I put a section on the Singapore Convention also. So I am quite clear on this aspect that we need to move away from the confusion that has been created around this.
Yeah, and let's try to clarify. And as ICSID themselves differentiated, the role of the Conciliation Commission is to clarify the issues in dispute, whereas the role of the mediator is to solely assist the parties with reaching a mutually agreeable solution.
Exactly.
That's the main difference.
Yeah, and this is where the thing lies, because for me, up till the point of time that whatever the solution is not imposed on the parties, I'm going to still keep it under the broad term called mediation. But you can use any term. So I'm just putting it out for you, the definition. We just go through that, because I keep talking about this. So this is where the definition is. This from here. This is how it defines it. So when you say what you said about conciliation, does it fit into this? I think so, because the mediator is not imposing, or the conciliator is not imposing a solution on you. So it fits in here. Now let's look at what I told you, the model law that was taken out by Uncitral. Let's look at how they've defined it. This is how they've defined mediation. So they specifically said could be called conciliation or any expression.
Yes, but they specifically said the mediator does not have the authority to impose upon the parties a solution to dispute.
That's it.
But a conciliator can.
That we'll have to have a look at. That's why I said, wherever specifically there's a provision that it is a binding thing with the conciliator, then there's no difference between arbitration and that. Then there is nothing. But as long as it is non-binding, but you are saying that the conciliator will suggest a solution, or may suggest, or will, or may, we'll have to have a look at the terminology used, because these are going to be specific situations. So if it is may, I don't have a problem. If it is will, I don't have a problem. As long as the end of the day, it is not binding on the parties. I'm okay with that, because I'm telling you, because when we keep confusing the user with these things, they stay away from it, the process itself. They don't know which one should be put. Should we put mediation? Should we put conciliation? This works that way, that works that way.
There's maybe one more thing that should be mentioned. If you use, and if you look at the ICSID rules that have been in force since March 31st this year, conciliation rules at ICSID are reserved for member states. Mediation rules are not. Mediation can be used by anybody, anywhere, and you can use ICSID to facilitate mediation as such, provide you with offices, the whole infrastructure in order for you to reach an amicable solution. But conciliation is reserved for member states. So there's a much more space for everybody in mediation. And like I said, I only think of conciliation as something that should be used as a process where there are substantial technical issues that should be resolved. And when you look at the example which I mentioned earlier, or which you mentioned earlier in Peru, I believe, there is much more room in mediation to differentiate, provide each other with interests and opinions. Conciliation is focused. This is not. This is broad. This is something that provides you to fully understand each other. And there is a big place for mediation here, not just in terms of flexibility, costs, duration, but when you dive into the process, you can always find something for you to discuss. And every mediator who has experience knows that you can always find some questions that are maybe not related to the subject matter, but are connected somehow, and mediation provides a mechanism to resolve even those issues.
I think basically maybe within ourselves first we should as mediators or conciliators. I mean, some people want to call that. I earlier used to write mediator, conciliator. I have removed conciliator because now I'm focusing on this, that mediation is broad enough to cover conciliation. So let's just use one word. Let us not confuse users. If first thing is the parties themselves, if they want the mediator to suggest a solution, they can tell the mediator to do so. They don't want it, they can tell the mediator they don't want it to suggest. If they want it facilitated only to facilitate, they can tell the mediator. I don't think that should be issue. But to create this whole confusion around those two words, the user might stay away. That's what I don't, because they don't know what they want. Because when we create this very technical thing around conciliation and we say, look, this is a very technical thing and the conciliator will maybe suggest certain things and all, they start getting scared. Maybe, oh, is this something like arbitration? And today I'm telling you, in 1996, we have a law on conciliation here, which is nothing. It says that the conciliator may suggest, that's all. But and you have to keep that there, because otherwise tomorrow that settlement agreement might get challenged, saying that this was something which was suggested by the conciliator. So
Yes.
you have to put it there that, look, that was part of the whole thing that they may suggest, but was it imposed on you, that solution? No, then perfectly all right. So I'm just trying to say that I think we're creating too much around that. And I feel that countries are moving away from arbitration only because of certain reasons in relation to, I said, maybe the pool or their experience with arbitration. And then we again bring in another concept saying, okay, this process can be something which a person might suggest, or you have the other route, which is mediation, which is facilitative, and they don't understand the difference between the two because obviously they haven't used it. So they might just stay away from the process itself because they might
Yes.
take from the same experience they've had earlier. So I'm just saying that the fact that we have to keep pushing through is that there is no authority to impose a solution on you. You have nothing to fear. It is your settlement, your terms. Only when you sign it, then it becomes final and binding. This is all we
Yes.
have to keep telling them. I think that's the education that is required, and I don't know whether that's the way it's being.
I'm here to assist. I'm here to assist.
Exactly, and it is yours.
I
And
have a
this,
colleague here. Whenever she's contacting the other party, she always says, "There's a chance for you to do some good here," and it works every time like a charm. There's a chance for you to do some good here, because people want to feel good. They want to resolve something. They want to do a good deed. And I sat with her the other day, and she had a call, and the instant she said, you have a chance to do some good here, the party said yes. I don't know, it's
Yeah, yeah.
maybe the highest selling point for mediation. And when you discuss the issues that are involved in investor state disputes, there is always several chances and several good deeds to be done.
No, that's what I'm saying, that even the fact that you said about the mining projects, just the fact that there is a community which has been located there and it's been there for generations, and you
Yeah,
want to an arbitration, you just might say that the community has to whatever. I mean, it has to move, whatever has to happen. We don't know what kind of thing comes out from that. And in this case, you can't really. I mean, you have to look at the from the country's perspective also. Are they going to have a resistance coming through? Can it reach go into
yes,
violence after that? Are you going to be able to, should you be first of all taking that risk? So if it is an amicable settlement and all parties are put together, these are the kind of things we have to push and talk about, which I don't think those conversations are really happening. Because I mean, like I have Luis Ore and Ivan, both of them from Peru. I've had them on my shows. You must listen to what the work they're doing, and I really find it something which needs to be done everywhere. People don't know about that work that they're doing there, and they've actually looked at these mining projects, and on a large scale. I mean, there was one Louis was showing us. They took a stadium, so they had the entire community in the stadium. They had this was during the COVID times. They had the government officials on the screen, so hybrid thing happening there. Wonderful work. So I think
yeah,
it has to be highlighted, pushed there, that look, this is the reason why mediation should be used, because you can't do this in an arbitration. Can you
yeah,
get these voices in? And that's finally for the country, that's important. That's the most
yeah,
important aspect.
yeah, and it reflects the country's resolution to do some good for their citizens.
Yeah.
That's the reason why every country in the world is fighting for foreign investors, for somebody to come to bring technology, knowledge, jobs for whatever community they decide to invest on, whichever industry they decide to invest on. My country has a lot of foreign investors here who are doing business here for years. The new ones are coming every year, and especially from the EU. And most people here from the local communities depend on those jobs. So my country is working very hard to keep those jobs and keep those people working. Otherwise, what's the point? That's the whole point of the government, to assist people and facilitate as much better living conditions for everybody as possible.
Absolutely. Absolutely. So, Nicola, at this point of time, you'll have to just a closing kind of whatever you want to close it at, and then, of course, this discussion has to go on. This is just a starting point. So,
Yeah.
how would you like to close this particular session?
Well, I believe that this is a topic that will be further discussed and will be further developed. We're on a starting point of something very, very beautiful. And even though it's concerning investor state disputes, but I believe that dealing in this topic, there's much more development in mediation that has happened than, I don't know, in the past decade, than in the 30 or 40 years before that. So we have to embrace this development and join the discussion with everybody. Not, you can do whatever types of mediation you want, but follow through, watch. You will find something that is developing further. You can apply it, you can work it into your practice.
Yep. Perfect. So, thank you very much. And I
Thank you,
think, yeah.
Vikram.
And of course, mediation is in good hands if you are there. So
Thank you.
that's
Thank
so.
you.
I'll close this here. I think maybe we have to first, I think, develop mediation in the domestic market for countries to take it up in their investment treaties. So I think we need to work, of course, on the domestic for sure. So we'll of course keep
We need
working on that.
to.
Yeah,
I think we need to work both fronts,
yeah, definitely.
internationally, domestically, and when we find ourselves in the middle, it will be done.
Yeah, and I think also the fact that with the Singapore Convention there, let us see how those things go ahead, how when these settlement agreements do reach those countries, what really happens, how do the countries look at it, how do their courts to enforce it, what issues come up. Let's see what happens there, because that's also going to be new for them when that happens. So,
Yeah,
and of
we're
course,
developing.
and when of course we'll have to see the kind of dispute it is, whether tomorrow certain things will not be covered under the Singapore Convention, maybe what happens in those situations. So lots of discussions there. So what